because of e-filing, we anticipate in the future the copy fund is going to be less, not more. And so we are really suffering on the revenue side. In the meantime, the Supreme Court and the Court of Appeals, our filings are at historical highs. They continue to climb, and a lot of that is business litigation. It's difficult, it's complex, and it takes a lot of man hours to deal with it. As you all know, especially you lawyers on the committee, we are under, as the Supreme Court is, a 2-term deadline. We have 3 terms of court a year. Cases have to be filed and docketed, and within 2 terms, they have to be out. And it's like y'all's last day of the session. And so we have to get all the cases out by midnight 3 times a year. We have not missed the deadline, but I will tell you, distress is coming up. And we talked about that this morning. This may be the most difficult distress we've ever had. So our cases are up. Our money's down. There's a lot of good folks behind us that are here asking for the same thing. They got more work, less money to deal with it. But the things I wanted to address was to let you know that our caseloads continue to climb, our e-filings have continued to climb, and we're still suffering from this hole in our budget of $225,000 from about 3 years ago. We're here asking y'all to restore that and also give us the maintenance money on the e-filing system. I'll be happy to take any questions.
Okay. Thank you, Judge. Do we have any questions from the committee? Surely he was not that good.
Well, when you ain't got no money, I mean. I will remind y'all, some of y'all that were on the committee, a year or 2 ago, I came down here and we had this little dice thing that we used to shake up and roll the dice to where we did some of the random selection of some of the cases that came in, conflict cases, that sort of thing. I'm happy to report that we have now terminated that, and we're all on the e-filing and on the random wheel, and the computer does all that, Chairman Willard, so we don't have to shake the dice anymore. 21st century, we've come a long ways.
I knew if we stalled long enough, we'd get some bites here. Chairman Willard.
Thank you, Mr. Chairman. It's great to see you here. Judge Ellington?
Thank you.
Judge Phipps? So the electronic filing, that's all, is that, I see some stuff you gave us here. We're ready to go on that, and that's going to be, instead of you guys having to take the copies, it's going to be all in place, right?
Well, it is in place. It's working, and as you can tell from the information and what I told you, the filings are up 72%. So the lawyers are taking to it. And not only that, I mean, I consider myself a fossil head. I've been practicing law and been around this business a long time. But the new baby lawyers that are coming out of law school, I mean, that's all they know. That's all they understand. And so as it goes forward, it's going to be more and more and more on the e-file system, which does save us man hours in the future and money. It's more efficient.
And what I understand is that if the records are if it's a substantial record, you have a difficulty with taking it because of lack of equipment and being ability or capacity, I guess, at the Court of Appeals.
Right, and we're still taking baby steps as far as getting the total electronic records from the counties and from the circuits and getting it up. But there are some pilot programs. There's some joint programs that are going on throughout the state, and the feedback on that so far is good. It's going to take money. We've never hidden that fact. The last thing I'll mention is that $33,000 in there for maintenance, or $30,000 that we've asked for maintenance, is something that we're going to have to pay whether y'all give us the money for it or not. If that means we've got to take a furlough day at the end of the year, I mean, that money is incurred. And that's just something we've got to do that's been imposed upon us, just like rent at the GBA. And so we don't have a choice in that matter at this point. It's got to be paid. And at the Court of Appeals today, Judge Phipps and I have been there for 14 years. We have 11 less employees today at the Court of Appeals than when we got there 14 years ago. And of course, the caseload has exploded in that 14 years. But we've got less employees and less money, less payroll, but we still have to pay the GBA whatever the GBA says we have to pay them. And we don't have a choice in that matter. But personnel is really all we've got.
Thanks, sir. Well, one other question, if I could,
Certainly.
Mr. Chairman. And I see where you've got the increase in funds for one-time purchase of software for e-voting. That's for the that's for you guys to be able to vote.
Well, that yes, and that's simplified where we could vote e-voting for the judges. But what that really is that's the first step in the process. And I would love to show you and educate you the way we do business. But we've got special wheelbarrows over there that you push these papers around on. They're carts that are just loaded up with these cases. Some of them have 1 volume, some of them have 55 volumes, and it's a lot of paper. And we actually had to push that stuff up and down the halls all the way over to the clerk's office, which is in another building, and that takes manpower, that takes resources. And this e-voting is the first step in eliminating that. It will eliminate steps, it will eliminate time and efficiencies as far as our workload. Now that is something we have asked for, that's something we'd love to have. But that's something, you know, that we might can live without. The personnel money and the maintenance money is something we cannot live without.
Okay. Thanks, sir. You need it.
Are there other questions from the members? What was the total cost of to implement the e-filing?
Okay, my clerk is reminding me it's not just e-filing. That's what we love to call it, and but it's a case management system and a docket system. And I'm going to ask her if she will. She's got a spreadsheet on that.
If you give her the microphone there.
All right. I want to explain. We keep talking about e-filing, but really what we're speaking about is something larger for this court. It's what we call the electronic case management system. Electronic filing by attorneys is one piece of it. We completed the development of the electronic filing, and they're doing it every day. I mean, that's what we deal with, electronic filings. The majority of filings probably coming into the court that are from attorneys are electronic now. And by itself, electronic filing was $150,000 that we spent. Now, that money was a combination of our other funds and money that was in our operations budget. You did not make a special appropriation.
Right. It was not appropriated from.
Right. After that step, we had our docket recreated as a new electronic docket that would be efficient to work with the e-filing partial system. And so now we have a new docket. We're using that every day. It is completed. So we're doing that, and that cost us $151,000 approximately. Again, that money was not appropriated. It was either through operations or through our other funds, the combinations of documents. We are spending now $48,000 in new docket enhancements. After we finished the new docket, we realized there were additional things or ways that we can make it even more efficient. So we're spending you have appropriated some money to us for electronic trial court records to be sent to us. And we are working on designing and implementing that now. That money is in two pieces, $52,000 and $58,000. And we haven't spent all that money yet. We are working to implement that so we can receive those big volumes that several of you have talked about electronically, which is going to be a long process. We have 159 counties. We have multiple levels of trial courts. So we're going to create a system and then one by one start adding these courts to be able to do it. And then so I think that, so we're talking about $500,000 when it's all completed. And then we have a few things that we have the maintenance, which was we got $12,000 in maintenance at one point, and we're asking for the $33,000, which will be the only two ongoing costs. And then in the future, and you'll see this, I think you had a handout of all the things. In the future, we want to do the electronic voting for the judges. We want to do electronic circulation of the cases. And we know the electronic voting is about $30,000. We don't know yet what the electronic circulation would be. But they are add-ons until we have a complete electronic case management system. So does that answer your question? I hope.
It does, and I thank you, and I know the committee thanks you for that information there. Chairman Wellen.
Thank you, Mr. Chairman. You need electronic case management in order to see an efficiency to gained by the electronic filing, don't you?
Correct. And I think if we had not had developed what we did at this time with the loss of the 11 positions, we wouldn't be able to have completed what we have to this day.
Yeah, and that's what that's done is it's helped you the development of the case management system to the point where it is now. Not that it's reached where it needs to be.
Correct.
But that's how you've dealt with the loss of the 11 people, or part of how you dealt with it.
Correct.
Okay. Thank you. I appreciate the efficiency that's been done there.
Are there any other questions? If not, we appreciate you coming, and thank y'all for the things that you do for the state and the service that you provide.
Thanks so much.
The next one will be the Criminal Justice Coordinating Council. I was instructed otherwise.
Good afternoon, members of the committee.
Thank you. We look forward to hearing from you. Thank you.
Well, I've been on the job about 7 months. My name is Braxton Cotton, for those of you that don't know me. And as always, this is a privilege to take part in of our government at work, so to speak. So bear with me. This is the first time I've done this. So be gentle, please.
Shouldn't have said that.
Okay, what we've got in front of you is a little PowerPoint presentation kind of that we can go off of, and I've got the budget book here, but it's going to cover, I guess, 29 of FY14, kind of on down. We'll probably hit the highlights.
Is this where we need to explain that?
Okay, so this PowerPoint presentation that we have in front of you, I guess it starts at page 2. This is kind of what we have achieved, or what some of the impacts are of a 3% cut that we had sustained in AFY 13. Total, $11.9 million total, $11.6 million with the accountability courts, and $344,000 of state funds go to our typical operating cost. With the 3% reduction, it's $10,500 reduction in temporary labor for FY13, and we're going to carry that over to FY14. In that, it's reflected in a movement of IT positions to other funds and grant funds, and those responsibilities have been transferred over to our CIO. Now, in the request for FY14, we're asking for $157,153, and that's to support the fiscal management of the accountability courts. The next page is just basically going over basically what the FY budget was for 2013 for those new members, as well as just to remind everybody, it's kind of the language that the legislature set up for these accountability courts last year. So in that, just to highlight, with the $9.3 million in felony courts, it's been an establishment of about 45 new additional awards, or awards total. With the DUI, family, and juvenile courts, 58 new courts, and then the $750,000 for DOC pilot projects. This is just another slide to kind of show how the money is flowing. Total applications at the second half of the presentation is kind of where the rubber meets the road. The Accountability Court Funding Committee received 103 applications and made about 101 awards. So total. So we're doing pretty good. In that, about 20 new implementation courts were started with that. The next slide is just another expenditure breakdown. It's pretty self-explanatory. Okay, just to give you a little background on the Criminal Justice Coordinating Council and the Accountability Court's grant staff. All total, everybody that handles grants at the CJCC is about 20 and a half employees. With that, we manage about $23 million to $30 million every year that we receive from the federal government. With that, the grant staff's workload is on average around 45 subgrantees. So each grant specialist monitors expenditures and just general reporting and has those relationships with about 45 subgrantees, so it's 1 to 45. In FY 08 to 12, we managed about 27 funding streams, which is one of the largest in the state when you start talking about different funding streams. And they totaled about $138 million total. And we issued approximately 1,400 awards. So with that, what these grant specialists really do is they basically monitor when a subgrantee submits a budget. They, hand by hand, to be sure that we're in compliance with all types of federal regulations, they go down the list and be sure that anything that they're requesting a reimbursement for has actually been addressed in their budget that they requested through the subgrantee process.
Mr. Chairman.
Time out. Mainly what we're interested in is how the accountability court funding went this year, since
Yes, sir.
that is a new program. And also in last year's budget, we did not put any administrative funds in your budget because we anticipated that you would be able to do it with existing staff. And so now we're seeing a request in 14 for additional administrative staff. And so we sort of want an explanation for that. So the two things we're mainly interested in are, number one, how did the transition from what we were doing through AOC went when the grant funding went to CJCC, and also to see how the working relationship is going between AOC and CJCC as far as, because when we did the funding last year, we weren't really sure who was going to be responsible for monitoring, auditing, who was going to be responsible for continuing the best practices, setting forth the standards. So we'd sort of like to know how that is working between those two agencies, why the additional funding is needed, and basically how the program worked. That's what we're looking for.
Yes, Mr. Chairman. If you go to slide 7, if you go to page 7, it's basically, this is where the meat and potatoes are. One full-time employee right now is managing about 103 subgrantees. I already made mention that 45 is typically the average for one grant specialist. So in that, it cost the state, because I can't fund any of those positions I can't fund any of those positions or anybody that's working on accountability court stuff with federal grants. I can't do it. It's against federal law, regulations. So it costs about $157,000 to run the way we run, and it'll be in the next slide, actually, basically what you get, what you pay for. If you go to the next slide, just real briefly, these are all of the things that you get by having the accountability courts over at the CJCC. We are a grant shop, soup to nuts. You get basically transparency. You get every time that somebody has submitted a budget, you have a right hand to left hand, by the numbers, look to be sure that the state is getting the biggest bang for their buck and that money is being spent as it was intended on being spent as far as within our shop. Fiscally, as you know, we're the bank to be sure that we're not wasting any money. Now, with this, I made mention of $157,000. If you go 2 slides, or 3 slides, it says CJCC grants and operations. It's pretty plain. We have total because of the budget language from last year, we have to use our existing state funds to be able to fulfill this obligation. We have $344,000 of state funds that are appropriated through the legislature to our agency, total. In that, we have certain match requirements that we were required to make to the federal government, and they are listed as such. $18,000 for RSAT for matching requirement, and $88,000 for VAWA matching requirement, and for VOCA it's a maintenance of effort, which is basically a formula that this federal government says that basically amounts to about $40,000. So all that total leaves us about $198,000 of state funds left that we operate off of. With me being here to testify today, I can't pay myself, or we can't use federal funds to do this. So it's a dynamic shift and move when you start talking about federal grants and being in compliance with all the requirements for federal grants. So with that, if you were to subtract, I mean, simple arithmetic, if you were to subtract $157,000 from $98,000, that's what our shortage would be. We would not be able to, fulfill our federal requirements, and we would jeopardize being able to draw down federal funds. I mentioned $23 million to $30 million a year, so that's kind of where we are. That's why we made the ask.
Mr. Chairman.
So the shortage is $60-something thousand?
No, sir. That's not the shortage. The shortage is $157,000 because that is what it cost. And there's another slide. And it's a pie graph. It's on page 9. This is what shows exactly how much money that are all of our grant programs and what it takes and requires to administer all these grant programs. There is cost involved in managing the different grant funds. So with the accountability courts, it's our largest grant that we administer, and it takes more than one person. Her name is Ursula Kelly. Right now is the principal employee that's working on the accountability courts. If you look, she's the only staff that we have dedicated to the management of this grant, or the administration of this grant. We still use and still tap into other employees to help to support this because this is the governor's office priority for us to handle. So all total, all cost involved with everyone that's included in to support this is what it costs. That's from the customer service standpoint. That's from any time that any type of reimbursement is asked to be made, something that folks don't think about. Anytime any type of reimbursement is made for travel or otherwise, it all comes through our shop. So 101 courts, it doesn't really seem like it unless you really think about it. Anytime we have to fill out any type of travel reimbursement or whatever, it comes through our hands, and it physically has to be processed through our body from the fiscal piece of it. Not just and I'm not talking on the programmatic piece, sir. I'm talking the money portion. It takes and it requires effort and support to be able to do this, and we've been able to do it because we've been moving money around, to be honest with you. But now it's the honest, right? So with all things being totaled, it takes a lot, and now we're coming to the phase where looking forward and projecting this down the line, we're really in some risk, and we don't want to jeopardize other federal money that we receive because we're not able to meet our minimum obligations to the federal government.
Mr. Chairman, may I go ahead and get Chairman Willard? He's been blinking.
No, thank you. I just it blinks not because I'm doing it. I'm blinking all right. Thank you, Director. I want to ask you some follow-up because I'm going back historically. The governor's recommendation was increasing $10 million funding for the accountability courts. There was already a $2 million funding previously for that, so a total of $12 million funding. You have some flexibility in the use of those funds. You mentioned, of course, the federal funds come in with restrictions to it. Your state allocation doesn't have those restrictions. Have you been taking care of your administrative expenses with use of part of that $12 million or not?
Well, yes, sir. I mean, logically, that would be a good idea. Let's just use some of.
Have you?
No, sir. No, sir. We have not.
You have not. So everything
Wait a second. Let me understand your question.
is what? It was prohibited in our budget. Was it? Okay.
Yes, sir. That's what I was going to refer you to. If you go to slide 3,
Okay.
it's HB 746 language.
Okay.
Slide 3, not B.
Thank you. That's all I have.
Yes, sir.
Chairman Powell.
I hate to sort of get out of sync, but Marla, if maybe you could maybe take the podium over here. We
I am the CJCC board member.
okay.
She is.
But basically what I want to do, because they are asking about additional funding for staff positions. In our appropriation last year, we put 3 administrative staff positions in AOC to deal with accountability courts.
Yes.
And part of that was because we really didn't know how all of these things, all these pieces were going to work together.
Correct.
And my understanding is that at least one of those positions has been filled and is being utilized for best practices, standards for accountability courts.
We've actually had 2 people hired through the interim, and we had 3 at one point in time, and we've just filled the 3rd one. So we are keeping up. But I think what needs to be looked at is in 1176, the duties that were given to us and how we were to do that has been what the committee has been focused on, which includes the standards and information. And we have a handout, I think, that we gave to Brian to share with you all about what the committee has done and what the staff is doing.
I really don't know that in addition to what we've already done that we want to create any positions. So I think the position of the committee is that we're either going to have to reallocate resources and shift some positions around or leave everything as it is. But I don't know that we're in a position to create any new positions in either agency at this point. And so which is why I want to know, what do these 3 people do?
If you will look at the handout. Ashley, are you here? Do you have those copies? They do have them. Let me see if I can find it here in mine.
Oh, the photo.
It looks like this. And these are the basic charges that are outlined in 1176. One is to draft the standards and practices for all the accountability court programs, including standards for practices for drug and mental health court divisions, for consideration and adoption by the Judicial Council. That was done and in place by January 1, 2013. Then, yes. Oh, I'm sorry, the very first page. It's a separate handout. It's 2 sheets of paper stapled together. It is, yeah, the title of it is Judicial Council Accountability Court Committee. And attached to that, besides on the front where we have the charges and the status of each of the charges, what we're doing, there is also a list of the committee members behind there, and then there's also the actual budget, what was given to us, and then what we are on track to spend at this point in time. Do you want me to continue going over that?
Yes, ma'am.
Okay. So then in the second one, that is to guide the award of state grant funds to accountability court programs. We're to develop a certification and peer review process, starting with the felony drug and mental health courts, to document compliance with Judicial Council standards and practices by July 1. And we are on track to have those ready and approved at the Judicial Council meeting in April. The next is the protocol. We're developing protocols for technical assistance to accountability court programs to assist with their implementation of policy and practices outlined in the standards. We have a contract for technical assistance. There were a number of courts that participated in a survey. Those in particular have direct access for technical assistance, and those who were not able or did not participate in that survey that really evaluated and looked at the programs we're also making available to them technical assistance in that area. Then we are to identify the elements necessary for performance measurement of accountability court programs. And the status of that is we have a minimum set of performance measures and elements, and we are to analyze the data submitted by the accountability court programs, which we now have under the FY13 state grants, to inform the identification of other potential performance measures for felony and other programs to be considered by the Judicial Council Committee. We are also to identify the risk and needs assessment tools to be used by accountability court programs in determining the risk to recidivate and the needs of participants to avoid future criminal behavior. And we are looking at, a subcommittee has been formed to develop mental health treatment standards and to identify a risk and needs assessment tool for these courts. And we are on track to do that before July of this year. And then determine training and professional development priorities to promote the expansion and enhancement of accountability court programs. We are currently, we started almost before the beginning of the fiscal year this year, planning our annual conference next year. And this is a conference which is really, I think, second only to the National Drug Court Professionals Conference. We bring in nationally known people. We provide a lot of good programming for the people who work in these courts. This past year, we had almost 700 people attend. Our committee wanted to plan to, again, provide that same kind of conference experience, and that is what we're moving toward. And those are basically what our staff is doing and working with. I mean, we have gotten from the Criminal Justice Coordinating Council the information that we need to work on these, to review these grant applications and do these things. That is somewhat different than what I believe Mr. Cotton is talking about, because he is talking about that day-to-day check writing ability, that day-to-day, you know, checking to see that people are meeting, you know, when they turn in a reimbursement, is this something that can come under the grant? And Braxton, I don't mean to speak for you, but I believe that's what you're talking about.
Yes, ma'am.
All right, any questions of either CJCC or of Marla regarding just the accountability courts?
And I believe Judge Downs is here too, if you want to ask her. She is also a committee member.
Any questions? Gerald, are there any questions?
No, sir.
Oh. No
They
blinking lights.
No blinking lights, Mr.
Okay.
Chairman.
Thank y'all.
Thank you, Mr. Chairman.
Marla, are you trying to get close to the back door? Because you're next.
Well, actually, you know, if you don't have, no. I just wanted to say something to Judge Downs before she left. So are we next on the agenda? Okay.
Yeah, y'all want to take the table?
Good afternoon. I am here as chair of Judicial Council, and
Haven't we seen you leave recently?
recently. Yes.
I was amused when he was talking with CJCC about moving money around, and I thought we had that same discussion regarding e-filing initiative the other day.
Yes. I'm going to turn over the presentation to Marla Moore, Director of the Administrative Office of the Courts, but I'm here to answer any questions, and I'm here also to support the Administrative Office of the Courts, which I think is doing a wonderful job with all of their duties.
Thank you. Thank you. It's good to be here, I guess, again in front of those of you that I've seen before and some new faces as well. I am the Administrative Office of the Courts, the Director, and I have been there now 3.5 years, so this is my 4th time to go through this. So I don't feel any less angst than Braxton did coming here for the first time, so I will assure you of that. We have, the Chief and I have worked together during, as you know, a very challenging time for all of us. But I think that we have worked very diligently to work with you and take the cuts that we had to take and what we could do to live with those cuts and not only live but thrive with them. I just want to remind you briefly that for the actual AOC operations, which is what I'm going to speak to most, we have taken a 44% cut in our funding since I became the director in 2009. In order to meet that, we have reduced our state-funded positions by 43%. We have looked at all of our programs. We continue to look and assess projects to make sure we are doing what we're supposed to be doing with core mission. We closed a satellite office, and we have reduced our state funds travel by 58%. We use video conferencing and teleconferencing almost to a fault. We have purged and scanned files, reducing storage space and increasing our office space by 5,500 square feet, which resulted, and we have closed 2 off-site storage facilities. So we are doing a lot to downsize and live within our means. Our budget, the AOC Judicial Council operating budget, is about $10.2 million. Of that, 1.7 goes to support civil legal services for victims of domestic violence, and another $1 million of that is allocated to the Council of State Court Judges for their retirement system. That leaves about $6.1 million for the actual operating budget of the AOC Judicial Council. Of that, 90% is personnel services, and about $750,000 of that is cash match for our Justice for Children project and our Child Support Collaborative, which are federal funds that come in. Our fixed costs are our rent, our IT infrastructure maintenance, and we support both internal operations and we also support outside operations. We actually are providing case management service to about 290 courts across the state. There was, I would note, there was a letter, I believe, last May notifying us of a rent increase. We did not include that in our budget. We do not plan to ask for that at this time, and likely will not until we get to the 2015 budget. We will absorb that part. We have launched a new website, which is much more user-friendly. We provide a lot of our service through that, and a lot of our information goes through that. Our Courts Journal, our On Balance publications are all web-based. We have done away with printing many of the publications that we used to do. We have traditionally done a lot of work in collecting information about the courts, and we have done that in sort of the same fashion. We are, as some of you know, this is our 40th year anniversary. We were created 40 years ago. And so some of the things, you sort of do because you've done it. We have been looking at a lot of those things. We have also looked at how we have been collecting data on the courts, and we think we can do a better job. So we have launched a biennial project to collect data on our judicial and court employee personnel services and operating expenditures in the trial courts. This court cost study will build a baseline on which to assess judicial needs. We believe we're going to be able to give you some very much better information when it comes to what our judicial needs are. We have increased the use of social media to keep our constituents informed about the judicial issues around the state. And we have we are developing a comprehensive licensure and training tool to automate all of our certification and licensing processes. And I just will remind you that we license court reporters. We have about 1,065 court reporters in the state, another 100 court reporting firms. In our language access program, we have certified 163 that we are maintaining certification on. Our Office of Dispute Resolution licenses and certifies over 2,000 people. Our County and Municipal Probation and Advisory Council, between our county and municipal systems and our private probation providers, there is about 90 of those programs that we are certifying. Our Family Violence Intervention programs is about 90, and we have judicial training councils where we keep information on the training, mandatory training that our judges are to attend. And in the last couple of years, we have added court process servers to that list of duties that you have given us to do, and we have been able to do that completely without additional funds because we charge a testing fee, and that has completely paid for the testing of those court process servers. So we're very proud of that. And of the programs where we can charge fees, 80% of those are funded by user fees, not by state funds. Last year, or in this year actually, FY13, you have given us some funds to do a pilot project for remote interpreting. We have purchased equipment, we have contracted with some interpreters, and we have been piloting that in 2 sites. We are now assessing the program, looking to some additional sites where we might move that equipment and use it, but we are very encouraged with the results that we're getting. We're also reaching out to courts to see where we might be able to expand the program, and you will remember that we intend this to be a user fee-based program, that we would not ask for additional funding on that. We also are engaged in strategic planning with the Judicial Council. After 40 years, we thought we might need to have a plan. So the other things that I would like to talk to you about are some enhancements that we have put on here. And you will note that in the Judicial Council budget, there are not only the Judicial Council and the Administrative Office of the Courts, but there are some other programs. Some of those have outside policy bodies, like the Judicial Qualifications Commission, the Institute of Continuing Judicial Education, and the Office of Dispute Resolution. The Office of Dispute Resolution, their staff has been moved into the AOC, and they are part of the Administrative Office of the Courts, and they are completely fee-funded. But the request that we have that I would like to talk to you first about would be the Institute of Continuing Judicial Education, which I am a board member of as well. And we have Judge Studdard here, who, if you have any questions, will be happy to talk with you about it as well. The reason that we are asking for this funding is you will know that our judicial education program has been cut even more severely than all of our other programs. And what the state funding now pays for is really the administrative costs of staff, the overhead for office space, the vacuum cleaner to clean the offices, which they do themselves, computer equipment, and the computer equipment is running out and dying. With any cuts and not getting this small amount, this $30,580, the board has looked at the numbers, and we are trying to hold the line on not increasing the per person cost that we are now charging for the programmatic piece. This money would go merely for that infrastructure. It is not anything that would go for actual programmatic. That is being funded by user fees, and that is the reason for that request. Yes?
All right, any questions about the continuing judicial education component? Okay, continue.
Okay. The next one, I'd like to go back to 6.3, which is the Georgia statewide judicial e-filing. This
I
was
really don't think we need to talk about that. We talked about it day before yesterday.
I'm happy then.
Next.
I just want to make sure if you had any questions, I'm
Next.
ready.
Okay.
Okay. There are two other requests, and I know that there are people here to speak about both of them. And it doesn't matter to me which one goes first. Do you want to talk about the probate judges first?
Talk about the rural judicial circuits
Okay,
first.
the rural judicial circuit, and again, we have a couple of people here, Judge Joe Bishop and Mr. Monahan, I think. They can come forward. You will recall that we had piloted in the Appalachian Circuit a Family Law Information Center, and that was funded in continuation last year. And so our request is building on that, is where else we can put this. So I would like for these two gentlemen to talk about what our current request is. You want to go first?
Sure. Hello. Thanks for the opportunity to speak to you this afternoon. I'm Mike Monahan. My current role is Director of the State Bar of Georgia Pro Bono Project, so I work with lawyers around the state in public interest programs. As a little bit of background, when I first got out of law school in, I hate to say this, 1989, my first job was in Tifton, Georgia, in a small town, small city. And I learned to be a lawyer under Judge Gray, Judge Forehand, and a number of other fine gentlemen who were really cared about access to the courts and felt very badly about how people interfaced and could not interface with the courts when they did not have a lawyer. In my job today, I understand how people do not get a lawyer because you have in front of you some statistics about where the lawyers are in this one rural area in southwest Georgia, the poverty population. But also know that, generally speaking, in Georgia, 70% of the state's lawyers are, well, nearly 70% of the state's lawyers are in the 5-county metro area. 72% of the state's poor are outside the 5-county metro area. So the burden of pro bono falls most heavily on the solo and small firm lawyer in Georgia. And I hate to use the word burden, but that's what it is. Pro bono is a solution, but it's not the only solution. And these family law information centers that are part of this proposal today are another part of the great solution of getting clients access to the courts, access to good customer service in courts that are open to all of the public. Now, one of the these court-based systems really, in their in the most basic, engender trust in the courts. People know that if they go in, they'll get some kind of service, they'll understand what the problem is, and be able to walk away with a solution. We also are centers for pro bono. They're centers for increasing low bono services, and they also centers for increasing referral to lawyers for people who can actually pay full fare at some point but don't know how to access the system. You also have in this part of Georgia lawyers, as you see here, a number of lawyers, but not many. They may not handle the kind of legal problem that the people there have. It's been a trend across the country in the area of family law for lawyers to move away from the practice of family law for at least the past 10 years. We had a small bump up in the number of family law lawyers practicing in that area of law here in Georgia when the real estate market went sour. Lawyers found some other work to do. But again, we don't have very many lawyers practicing family law across the state of Georgia. So a family law information center really serves a great purpose of getting forms, getting people into the courts and helped. The Judge Gray, Judge Forehand saw a number of pro se people before them that they could not help. Today, the calendar, the dockets are full of pro se people because the numbers have not changed. The population's increased. The world is far more complex than it ever was in 1989. And we have technology now that these flicks can take advantage of and are taking advantage of and making web-based services available which increase efficiency. They're great models for reducing the frustration that the public has with the system, whatever the system happens to be, largely government. They find is the system that they're having problems with. It's also, in essence, what they do is provide forms. They provide people to explain the forms, to move them through the system, to reduce the repetitiveness, the visits that people often make. They file something, it doesn't work, they're thrown back out. They come back, they try again. They've made another mistake in the pleading, they're thrown back out. So the forms are provided for them, and they're vetted by lawyers, by the court staff themselves, so we know the forms are good. We know they're going to work when they're provided. We also have web-based services for one of the websites, well, for the Appalachian Circuit, which is an example here. I provide free of charge the web template and the services to keep that website going and the forms going, and they provide all the other background services. But I do that as a courtesy because this is a great learning example for us in the public interest community to see how we can tie in with these court-based centers. These are locus for other activities in the community as well. So in short, the centers create efficiency, they create trust in the system, and they give folks who are less than enthusiastic about the law a better appreciation of the work that has to go into presenting a case and bring it to finality. And it lends order to chaos in family and household situations. And I'm happy to answer any questions you may have, but wait here. I'll give you the microphone. Yeah.
And I'm Joe Bishop. I'm the Chief Judge of Patola Judicial Circuit, which probably two of you I know are really clued in on where that is. It's Southwest Georgia, Terrell, Randolph, Clay, Quitman, Miller, Seminole, and Early counties. And I believe my purpose is to be here to tell you that, yes, there is a place that is vitally interested in a family law information center such as what has been described, and there is a vital need for it. I guess I'm the spokesperson, but there's a red-headed clerk in Randolph County who would probably hug your neck, Representative Green, if this were available. This process of presenting papers, resubmitting them, presenting papers, resubmitting them, is actually what's going on. And the people who are doing that, who are dealing with that now, are, in my circuit, are the Superior Court clerks and members of, well, my law clerk and me. And obviously that creates a level of frustration with the courts, access to the courts, and this certainly would be an enhancement that would help people, and it will help poor people. There's no question about that. Folks that otherwise don't have access but need it, and it will be helpful in the domestic violence area too. And if you've looked at the statistics, we certainly, for having a low population area, are leading this state in domestic violence issues, particularly deaths. And I'll be glad to try and answer any questions. That's what you want to.
Thank you, Judge Bishop. Any questions? Couple. Number one, we started this off with a pilot project. And the danger with any pilot projects is they tend to multiply, especially if somebody else finds out that they're out there and wants to replicate them. Ultimately, if the initial pilot project has been deemed a success, and obviously then it's needed elsewhere around the state, ultimately what are we looking at as the cost of this thing? Because, you know, that 100 and something thousand here and 100 and something thousand there, as Everett Dirksen said, you know, sooner or later you get up to real money. So what are we talking about?
I don't know that I'm the person to address that.
Well, first of all, how many circuits do we have?
We have 49.
All right, so if we did this same thing at this level in each circuit, I mean, we got poor people in each circuit, don't we?
Well, I don't think you really have to address it in every circuit, because you have some existing family law information type centers in the metropolitan area,
Okay.
and I'm not that familiar with them, except I know that they exist, and I think those are in the 5 metro areas. I think what we're talking about are places where there's nothing. There's nothing.
I'm familiar with those areas.
And there's no question that there may be requests for other family information centers, but in the long run, I think you're going to see greater efficiency in the court system and some money savings.
Right.
And they just have, I mean, these people have to have access to their court system.
My second question is, what would preclude us from doing something like we've done with ADR as far as it being self-funding from either filing fees or those kinds of things rather than state appropriations for these? And then my third question would be, what is the responsibility of the bar?
With respect to the responsibility of the bar, Mr. Monahan might be the better person to speak to it. Again, in larger areas where you have larger law firms, you have younger lawyers who are dedicated to pro bono projects. These 40 lawyers in the Patala circuit, they're just working to put bread on the table for family, and there really is not that much in terms of pro bono work. I can tell you there is one lawyer who handles about 3 of these cases, 3 to 5 a year, and looks after them fairly well.
I understand that the rural lawyers do a lot of unintended pro bono work.
They do. They do. And I'm sorry. I answered the second question first, and I've actually forgotten what the first question was. We don't have an ADR program either, so I don't know that I can address that. But I would think that you certainly could fund it in that fashion. I realize there's been a movement against having fees, add-ons to do that, but I will let you all certainly address that. If that would be a method to secure the funding, then certainly that would be potentially appropriate.
Any other questions? Thank you.
Thank you.
All right, wait a minute. I do have a question.
Well, no, it's just a statement, Mr. Chairman. Does
this have anything to do with the red-headed clerk in Randolph County?
And that's my judge, too.
And you're my representative, right?
And I know this group is going to treat them well. Absolutely.
All right, Marla, let's talk about Probate Court Judges Council, I think.
And I think we have some probate judges who want to come up and speak to that.
All right, for members of the committee, we're in 6.5, and we're talking about the request for the $108,320 to hire an executive director position.
Chairman Powell, my name is Linwood Jordan, Woody Jordan. I'm a probate judge from Forsyth County, and I'm here to speak on this request, which has been made by the Probate Judges Council through the Budget Committee of the Judicial Council, and the full Judicial Council has forwarded on to the governor, who forwarded it to you. We have several members of the leadership of the probate judges with us today. I don't know who's here in the room right now because we have another hearing going on upstairs, but our president, Mary Jo Buxton, is here along with our president-elect, Judge Kelly Powell. And finally, we have our Vice President, Chase Daughtry, who is also here. He's probably up in the hearing upstairs. The amount that's being requested is $108,000. That's total. The actual position request is for in the mid-60s. The rest is overhead. This is not an AOC request. I mentioned a moment ago that we went through the Judicial Council on this, and the Judicial Council approved. This comes from the Council of Probate Court Judges. And I don't know, let me just mention about the probate judges structure to you for those of you who aren't familiar with it. It's a bargain, I think, for the state. And I'm judging this. Before I became a judge, I practiced law for 30 years up in Forsyth County. And I'm in my 3rd term as probate judge. And I did not know what the council did as an attorney until I actually got involved in the council. And you may not know it, but over 57% of Georgia's population is in Article 6 expanded jurisdiction courts. And if we have the rest of the 8 counties who qualify come on through attrition of the probate judges, we'll have over 68% of the population in the state of Georgia, over 2/3 in Article 6 probate court jurisdiction. And to give you an example of what this means, Article 6 probate court jurisdictions have concurrent jurisdiction with superior court judges. They have to make the same qualifications of the judge as superior court judges. We have declaratory judgment concurrent jurisdiction with superior court judges on estate matters. And we do jury trials. And the appellate jurisdiction is straight from the probate court to the appellate courts. There's no superior court involvement whatsoever. And to give you an example of what a bargain that is for the state and for the citizens, my last jury trial that I conducted started on a Monday morning. It ran till Friday evening at 9 o'clock. And at that time I had two bailiffs come in, and one bailiff says, "Your Honor, we have a jury verdict." The other bailiff came in and said, "Your Honor, we have a settlement." So I won't tell you what happened after that, but the point I wanted to make, pardon? No, it's not. The point I want to make is that freed up a superior court judge for that whole week to do whatever needed to be done. This is what the probate judges are now doing for over half the population, and one day soon it'll be for over 2/3 of the population. And this is a wonderful system that the legislature and some other folks in the past devised, because obviously the Article 6 jurisdictions are in the larger counties, and by definition, and the smaller counties have the judges there full time taking care of the smaller counties' needs day after day. And this system works great. It's working well all over the state. In fact, in some of the small counties, I can think of one probate judge who was Superior Court Judge, Pro Hac Vici, probate judge, magistrate judge, and juvenile court judge in that county. So everything is all together right there, and so this is a wonderful system. But we're coming to a point where we need some additional assistance. We have absolutely no staff. For the last 3 centuries, since we were an ecclesiastical court coming over to Oglethorpe, we haven't asked for any staff, full-time staff for it whatsoever. So that's what we are doing now. We've increased the educational efforts of the probate court judges. We've partnered with Carl Vinson in addition to ICJE. We've started clerks trainings all over the state. There are several mentoring for the new judges. We just had a week-long training session for the new judges in Athens. We've completely revised the probate court rules to conform to the other courts in the state. We've got more forms than any other court, I believe, for the citizens to use. We're revamping them to make them easier for attorneys to use because of the problems that we were having with the way they were devised. Just all of this administrative and operational aspects that we need, and the judges just can't keep meeting in food courts and lawyers' offices and other places to try to get this done, because they've got to get their own work done too. And it's one staff position that we're asking for in this. And another thing that's concerning us is the demographics. As you've probably heard several times, we're about to have one of the greatest wealth transfers we've had with the baby boomers and their parents and so forth at this time. But we've also had some recent, within the past week, news that because of the baby boomers generation, the Alzheimer's is going to increase threefold in the next few decades, 3 decades, I think it is. And of course, we deal with all that too, the incapacitated adults, and we've seen that through the guardianship and conservatorship jurisdictions that we have. So basically, we've held out for a long time, and we feel that now it's necessary. The Judicial Council agrees with us that we need at least one person to help us do all these things that we've had to start doing, and I think it's a position that would aid the citizens greatly. And one final thing I want to mention is that this is not targeted. This is across all demographic strata, across all socioeconomic status, because everybody dies, everybody's going to have estates, or if not big estates, small estates they need to take care of. And the Alzheimer's and the dementia and the minors accidents and so forth are across all socioeconomic status. So this is not targeted. This is for everybody. So I'll be glad to take any questions that y'all might have.
All right, first question. The other councils, we've got municipal court judges, we've got magistrate court judges, we've got juvenile court judges, we've got state court judges, and we've got probate court judges. all of these different councils have their own executive director or own staff?
There are, yes. We've looked at that. There are many, well, a lot of staff on these other councils. If you look at the juvenile courts, they have field representatives all over the state. We have more probate judges, I think, than juvenile court judges. But we've carried the load ourselves, and probate judges have traditionally been an independent bunch. But they have executive directors and staff, and we don't have any staff, full-time staff whatsoever. And we're not married to the term executive director. If you want to call it probate court gopher, that's fine. But you know,
Does that cheapen it?
no. we just need some help is what it boils down to.
Do you, Marla, have a breakdown on what kind of staff is available to each one of these councils?
I believe that we contacted the, excuse me, can I just check?
Yep.
We do get along.
We get along well.
You better.
We did contact each of the councils and ask them to get that information to you. You know, basically, I can tell you, and I think we have, Mike, do you have the chart? Did we send that? The Council of Superior Court Judges, of course, has a staff, and they.
But they're sort of independent of everybody else, right?
That's
Not
right.
interested in them.
The Council of State Court Judges has an executive director and a part-time assistant. They are located in my office, and we work together very cooperatively. I think we have a really good relationship. The Council of Juvenile Court Judges actually had the first staff, separate staff, although initially they were housed with the Administrative Office of the Courts, and their executive director was a half-time each one, AOC, but that moved away many years ago. So they are the longest council to have had a staff. And then a few years ago, the magistrate judges got their own director. She also has an office at the Administrative Office of the Courts. And again, we work together. We still have duties with each of these councils. We provide fiscal services. We help with policy. You know, we do a lot of things with the lower court councils. Yes, here it is. And the municipal courts, for many years, we did all of the council-type duties for the magistrate, probate, and municipal courts. And with the decrease in our staff, I think particularly with things that were going on with the probate courts, they have felt that lack. And that is just something that we've tried to assist with and will continue to assist with. I think now that Mike Caccaro, who I think you know, is head of our governmental and trial court liaison, that we do have some resources there that can help, but that doesn't mean we can provide the service that they're asking for.
All right. All of those council positions that you're talking about, whether it be juvenile or state court or otherwise, are those all state-funded positions?
I believe they are for the most part. I don't.
All right. What I would like for y'all to do, because we understand your position, and we want to certainly not treat you like a foster stepchild so that you're the only council that doesn't have any help. And we want to get you some help, but we want to also try to find the most efficient way to do that. And what I would like to see furnished to the committee is a listing of all staff and their responsibilities for all of these other councils and what the cost is. And then we can look at what is the best way to, you know, whether we have to add some money to it or whether we have to reorganize them. But that's what we need, and if you could get that to Brian just as soon as possible.
Right. We did make the request. We did forward his request about
Okay.
that. And we gave him ours today, I think. So.
But, I mean, we would love to hear from the rest of your judges that you brought, but at the same time, we agree with you. It's just the best way to do it with tight resources is what we've got to come up with.
Just for your information, Mr. Chairman, I've got the juvenile listing here. There are 15 staff members.
Okay, if Marla doesn't have that, if you share it with her so she can share it with us. Thank you so much.
Thank you.
Thank y'all. Unless you got something else you want to say? Okay. All right. Thank y'all very much. You leaving me? Are you going to deal with juvenile matters? Amy's going to hear it. Amy is. Mm-hmm. No, I'm going to Ways and Means when I get through here. I would love to come visit with you. Okay. You gonna do? Brian, Commissioner. Listen, we got a picture of you. I'm gonna make you come sit by me. Leave me alone. Welcome back, Commissioner.
You ready, sir? I think you all know our CFO, Becky East, here.
Hey, Becky.
I'll be very quick on mine, Mr. Chairman, members of the subcommittee. There are just 3 statewide changes that you'll see in your document for us. You'll see, number 1, a reflection of an adjustment in telecommunications expense of a little over $1 million. Increase in employer share employee retirement system of about $13 million, and then an increase in funds for Teamworks, PeopleSoft billing, same as what we had previously. Did want to inform the subcommittee though of one reduction we're going to have to take or cover on our own actually, and we've been asked to cover the state health benefit plan employer share for 14 and cover that with $4 million of existing funds, which of course we will do. And sir, on the 14 budget, that's all I have. But I know you have some questions and some follow up on medical and some other issues.
Yeah, I got some follow up.
Yes, sir.
Tell me realistically, I mean, what is your assessment of the amount we can save on Medicaid, and what is the timeline when we can start achieving those savings?
I've got some new information for you from the last time. As you recall, the last time we met, I said that there were 93 claims outstanding, and the MOU was with DCH. We got the MOU yesterday. We signed off on it yesterday from them. They did some changes. I spoke to their commissioner today specifically, and he said as soon as it's put in his hands, he will sign it. So I feel really good about that movement. Trying to estimate the costs, as I said previously, just a week and a half or so ago, we had 93 claims outstanding. We're already up to 135 claims. So that's 40 plus more claims. And the best estimate I can give you on savings, we've actually had 15 inmates that were on Medicaid prior to coming into the system. So they were eligible for the Medicaid hospitalization. Those 15 inmates, we estimated savings due to this program, even though we haven't received them yet. We estimate the savings to be about $158,000. So those 15 inmates, estimated savings $158,000, $10,000 per inmate would be our earliest guess at this point. Obviously, we don't know if it's going to be greater, going to be less, but at least we have something to estimate. I also asked our medical staff to tell me annually how many total hospitalizations do we have of our inmates, and we're averaging about 1,440 hospitalizations. Now the trick is what proportion of those will be Medicaid eligible. So we're starting to be able to home in on a number, but that's all the data that I have up to this point.
I mean, do y'all have a process in place so that you can make sure that any potentially Medicaid reimbursement, I mean, that we aren't sending somebody to the hospital and then 2 months later saying, oh my God, that guy probably could have been Medicaid eligible if we had done that. I mean, we've got a process in place.
Absolutely.
Describe the process for us.
Our third-party administrator is primarily responsible for doing that. We scrub before any inmate goes out unless it's an emergency surgery, obviously. But if it's a planned surgery, we will scrub that inmate through our third-party TPA, what did I just say? Third-party administrator. And we put staff on there too to scrub that before it's a planned surgery to make sure if he or she is Medicaid eligible. And we know clearly there are 3 classes that are clearly eligible. pregnant females, the elderly, and the blind, so they're automatically eligible. But if we have anybody else eligible, that we apply for that reimbursement through DCH as well. I'm very happy with the process. It's just getting the MOU signed and the money moving.
Have you done any kind of evaluation by, like, maybe looking at 2010 or 2011 to just give you an idea that if we had had this in place at that time based on those kind of medicals, so that we can at least budget for some of these things?
I haven't, but I can certainly go back and do that.
Yeah,
That's
I mean,
actually a
hindsight's
very good idea.
20/20,
Yeah.
but that would give you some indication if 2010 or 2011 or 2012 are a typical year for, I mean, you may have had $200 million in cost one year, and you may have had 400 the next year. But if 200 is typical, look at what of those inmates would have been eligible and what of those charges would have been Medicaid eligible because they were done outside the fence and overnight and whatever kind of criteria are required. And let's just get an idea of what it is. So then if we do that as a benchmark, number one, we know how to budget for it. And number two, if we don't achieve the benchmark, then we've got something to measure it against as to why not, or did we pick something that wasn't in a typical year, or whatever it is.
I think that's a great suggestion. It would give us a good benchmark, or at least an estimate of what we could expect.
Okay.
So we'll go back and do that.
And even if we get that done after the budget process, if y'all could give it to Brian and give it to OPB so we can start sort of
Absolutely.
calculating on those things.
Absolutely.
Okay. Any questions of the committee on Medicaid or medical cost? All right. Tell us a little bit about jail subsidy. We had a change in last year, but this year we think we've got that because of some of the accountability courts and some of the other things that you've implemented, that we're going to keep that down so that we don't have a...
Yes, sir. Still feel very encouraged by that. Recall that in the 13 budget, you did move some money for us over so that we could cover those costs in 13, so I think we're going to be okay in 13. 14, it's hard to project, but I feel very confident, and we didn't get into it too much the last time, but of the 45,000 plus county jail beds that we have across the state of Georgia, approximately 11,000 are empty, not necessarily because, as we talked about, criminal justice reform, but a whole host of factors. One thing that encourages me when I take a look at those numbers, Chairman, one of those specific numbers is the number of offenders awaiting in jail a felony disposition. So that tells us it's probably a pretty serious charge, excuse me, or they would have bonded out. And that number over the last 4 years is essentially flatlined, and it's running at about 24,000 inmates over the past 4 years are sitting in county jails waiting for a felony disposition. So if that number holds, the empty jail beds hold, we continue to not get an influx of admissions, and the length of stay stays the same, I think we'll probably be able to cover our costs. I'm going to look at my CFO here next, cover our costs that's recommended in here without any redistributions or additional funds for 2014. So before I say that definitively, I'm going to look at Becky.
Well, notice he said hard to project. It is a very difficult number to project. We feel very confident right now because the numbers are very encouraging right now. Anything could change, and if any of those factors do change, then we would want to revisit that, and of course we can do that in the amended.
Okay.
Also on that topic, if I may, sir, I told you last time that Parole has changed some policies and allowed us to remission a facility of 446 beds up in Hart County. We have about 400 females in the county jail backlog, which is unusually high for us. But by opening that up, and it's about half filled right now, we think we're going to virtually eliminate that female backlog in the jails, which is also encouraging for 14.
Okay. Any questions about jail backlog by the committee? All right, then the final item on my list, and this may need some involvement by pardons and paroles. We keep having some discussion from legislators and from other parties who may be vendors about the difference between the probation call center and the automated call center that parole has, as far as which one is best, which one is most cost effective, which should we be using the same system because parole and probation have very similar functions. should probationers be paying for the cost of this just like parolees are paying? And I would like to have a little discussion about that, if you don't mind.
Sir, if I may, I'd ask Stan Cooper.
I knew you would.
Actually, if you go to the podium there, Mr. Cooper. For those of you who don't know Mr. Cooper, he's the State Director of Probation for the Department of Corrections, and he's obviously our expert.
Thank you, Commissioner. Good afternoon, Chairman Powell. It's good to see you again. Just to kind of give you a snapshot of where we're at, as you're aware, sir, with your service on the Criminal Justice Reform Committee, Georgia has some of the highest caseloads in the nation as far as felony probationers are concerned. Back in 2010, in an effort to assist with those caseloads growing at a rate of 29% over the last 10 years, we developed the concept of what we're calling the Probation Reporting Contact Center, and that is simply this. We partnered up with the Governor's Office on Customer Service using call center technology and developed a program where offenders can report in by telephone using an IVR or an interactive voice response, much less where they call into the center and basically ask a battery of questions, and they answer the questions. And the way it works is our centers, if they have an exception, in other words, let's say their address has changed, or they've been arrested for something, that call is immediately transferred to a call handler, live call handler right then, and can deal with that situation immediately. Last year when I come before this committee, we were supervising about 22,000 under that, or monitoring 22,000 under that. This year we're right at 36,000. Of about 84,000 felony probationers on our caseload that would be what we consider low-risk offenders. There's any tracks, I have looked at it. I have had a presentation to me a couple of years ago or a year and a half ago on that. It's a good program, and it works good for parole. It really does. But at the end of the day, for felony probation, we think the concept we have is much better. Let me share some things with you that is different for probation than parole. Number one, for us to order or to get an offender on this, a judge would have to order that offender go on to a program and pay for that. We can't make an offender pay for that. So that is number one. Number two is our records to be admissible in the court, we testify, my officers do, from business records constantly. And with a private company, if a private company owns those records, we can't testify from the business records as far as a revocation hearing or any court proceeding. So that also is a factor. And just, quite bluntly, when we were developing this system, we involved judges, prosecutors, and others in the process. And the one thing we heard loud and clear from them was this: we're opposed to anything concerning privatization of any form of supervision of felony probationers in this state. So we knew if we couldn't get their buy-in to helping us with this program, it wouldn't go anywhere. Simply what would happen is judges would order us to see people in the office, and that's what we would be doing. And so it would really hamper the system if we did that. So we are very excited about the potential for this. As you know, we collect fines, fees, restitution. Parole does collect restitution. We collected $50 million last year alone through the Department of Corrections on those items. Probationers also already pay a probation fee of $20 a month that we collect through that as well. And so with this program operating at the current cost today, it costs 5 cents a day. 5 cents a day to manage these offenders under this. Around $700,000 a year to manage over 35,000 offenders. Now, let me tell you what would happen if we didn't have this. We've got caseloads on the average of over 290 per officer in this state. That's about 170 more than what they probably should have. So this program has been a valuable tool in assisting them with monitoring that. With that,
Stan,
yes, sir.
let me interrupt you at this point. there's a $20 per month per probationer supervision fee.
That's correct, unless it's waived by the courts or
All right,
otherwise.
and that was my next question.
Mm-hmm.
How often is that waived?
Most of the time, it's if they're indigent or they have a medical or disability that they can't pay, we can't force them to pay.
Percentage-wise?
We collect around $11 million a year in those fees.
All right, what does your call center cost you?
$700,000 a year.
Okay.
Total.
So you are collecting $11 million a year in the probation supervision fee.
That's correct.
$700,000 of which, if you were looking at a surcharge, would be towards that.
That is correct.
All right, and the rest is going towards paying regular cost of probation.
That's true, sir.
Okay.
All right. And lastly, you know, there's been a lot of work with this, and the Criminal Justice Reform Council actually weighed in on this concept this year. A lot of good discussion on it. And one component that we're adding to it in the coming year is the drug testing component. That was one concern the judges and the prosecutors had. They'd like to see drug testing, so we're adding that component to that as well, where we have a random way of picking probationers to come in and report in to do that as well. So we're excited about it. We were very fortunate this past year, sir, to in November we were awarded by the Council on State Governments for this concept, the Innovations Award for the Southeast. And so we are very excited about the potential for this, and so we just think there's a huge difference between what we do and what any tracks or a private company could do.
All right, let me ask you another question. I'm changing the subject somewhat.
Yes, sir.
But because you and parole are working so closely together, y'all are occupying a lot of the same office space, trying to, as much as possible, merge what you do because it is very similar. And I noticed in their 14 budget that they have achieved a certain amount of savings because of their virtual office.
Correct.
Is there any benefit to that on the probation side, and tell me where y'all are in that?
Actually, it's funny that you asked that. We had a meeting earlier today just to talk about that, actually, and we actually do have a pilot going on down in Albany with parole on this concept. We expect to really, over the next year and a half, to really look at that concept for probation and parole and working closely together with that. So it's definitely something we want to look at.
So it does have some applicability to probation?
It does, sir.
Okay. Any questions from the committee? Stan, Becky, Commissioner, thank y'all.
Thank you, sir.
Pardons and paroles? Unless you've got a whole bunch of stuff you want to talk to us about, do you?
No, sir.
Okay.
As little as you want.
All right. Well, good. Talk to us a little bit about the virtual office.
I will, and thank you, Mr. Chairman and members of the committee. We entered into this concept, if you will, about a year and a half ago, exploring it, and I'll tell you how it came about. We would go around visiting offices, and we would go into those offices, and we would wonder, where's everybody at? Well, they were all out in the field supervising cases, which is exactly where they should be. From then, we looked at the feasibility of putting our officers out into the community 24/7 instead of in the office. In essence, going to where those offenders are instead of having the offender come to where you are. We did an initial pilot of that, and by the way, we realized that for the square footage we were paying in leases, that was only occupied on a real-time basis about 20% of the time. So not only are you talking about leases, but you're also talking about the telecom, you're also talking about, in some leases, the utilities that are associated with it. We set out to go on a 3-year plan within 3 years to be virtual in every one of our offices. With the 3% budget reduction, it forced us to move that timeline to about a year. I'm not saying that's a bad thing. Actually, I think it's a good thing because it kind of forced us to move a little bit quicker in a direction we were already headed. It was never intended to be budget savings. That was never the driver. Budget savings were a byproduct. It was really intended to put us out there in the community, in with law enforcement, in with our treatment providers, in the offender's home. You're much more successful doing an orientation of offender just released from prison in his home where everybody else is hearing the expectations instead of him not having a chance to get to the office because he doesn't have a driver's license or doesn't have transportation. So it put us right there in the community and has been just advantageous because of that. So much, in fact, that we went ahead, we compressed it to a year. This budget cycle, we were able to close 14 offices. Next budget cycle, we will be closing 19 offices. Now, an important piece of that is simply to reinvest just for 1 year, the 1 year savings reinvest, and instead of a fixed office, their office becomes mobile. They then have 2 officers to a vehicle. They then have their laptop in that vehicle. They then have printers that are wireless in the trunk to handle that, and they have a Droid platform that they can communicate off of. So that was the big advantage. In addition to that is the ability to move them from the office to the car, where after 1 year, year 2, 3, 4, 5, etc., you are realizing savings that were otherwise directly related to telecom, utilities, and lease savings.
And I would presume, because you aren't dealing with offenders coming to you and then you later having to go visit them in the community, that you actually can do more per officer?
Yes, sir. We can, and I'll tell
I'm
you.
not suggesting that we increase the number of probationers or parolees that they supervise. I'm just saying that whether they visit with a person once a month, they might be able to visit with them twice or 3 times a month.
You're absolutely correct, and it also affords us a better opportunity to visit with the employer, to visit with the treatment provider, to visit with other law enforcement officers within that community. So you have more of I guess, a holistic approach in dealing with that offender where everybody is then involved. So, yes, it increases efficiencies, but more importantly, I believe it increases effectiveness. And the whole, at the end of the day, the name of the game is supervising these offenders in a manner that prevents them from returning to prison. And the more we're out there amongst them, the more we're supervising them and those that interact with them, the more successful we're going to be.
Any questions about the virtual office from members of the committee? Talk to us a little bit. There has been an issue in the past as far as people who might have been eligible for parole, but there was not a place for them to go.
Yes, sir.
Is there, I know that's something you don't have any control over, but it's also something that reduces your ability to maybe draw people out of prison who would otherwise be eligible. What is being done on that front, or what can be done?
I'll tell you, if I may, sir, there's several things that is currently being done, and there's several things that have been done. One thing is when somebody gets beyond their tentative parole month, if the only thing keeping that them in prison is solely not having a residence, we release them. We release them to that parole officer at the county of conviction, who then assists them with finding a place to stay. I shared last year, as foolish as it may sound, they have a lot better chance of obtaining residency when they're not in prison. They get out, they make those contacts. It's easy to tell someone you can't come live here when they're in prison. When they come to your door, people are pretty much going to take them back, and that's what we did find. It was not that much of an issue. So that's one thing. That greatly reduced the other, them beyond their tentative parole month. The other things that we're doing is the reentry partnership housing, where if someone does not have a place to stay, then we parole them to one of those housings. That has worked very well. There are still approximately 700 that could go home today if they simply had a place to go. Of that 700, you're going to find that about 600 of them are sex offenders. And that's the challenge we have. Sex offenders are not allowed to participate in RPH. And additionally,
RPH.
I'm sorry, sir, the Reentry Partnership Housing Program. It is difficult because they can't participate in that, but even if they could, it is extremely difficult to find places for sex offenders to live because of the requirements and proximity requirements. So you have about 600. The other are mental health. And I'll tell you what we have done to that. We've done in conjunction with Department of Corrections, we have created what we call a Tier 2 Reentry Partnership Housing Program to specifically deal with mental health, where we had to get the providers to have some skin in the game, if you will. We did that by taking that RPH length from 3 months to 4 months and increasing the per diem that they are paid because of taking on mental health inmates. That has helped. And we're looking to continue to expand that.
Okay. Questions? Thank you very much.
Yes, sir.
Prosecuting attorneys. Okay, you better.
Good afternoon, Mr. Chairman. My name is Fred Bright. I'm privileged to be the chair of the Prosecuting Attorneys Council. I'm also the district attorney in the 8 County Okmulgee Judicial Circuit. Seated to my left, this is David Miller. He's the chair of our budget committee. Seated to my right is Chuck Spahas, our executive director. And behind me is Mark Williams. He's our CFO, chief financial officer. I'll let David, our kind of numbers cruncher, David Miller, run through our budget request.
All right, before we start, Chuck, I'm pleased to see that this is not going to cost you another $100,000.
Yes, sir. I'm slow, but I do learn, Mr. Chairman.
All right, David, go ahead.
Mr. Chairman, I know it's late today. Let me ask you, do you want me to run through each one of these items, or do y'all have specific things that you want us to address here? I'm happy to go through each item if that would be your preference.
I want to talk about the additional assistant district attorneys.
Okay.
I want to talk about the promotional increases. I want to talk about the annualized funds for deferred promotions. And briefly about the travel.
All right, sir.
We've talked about that a little bit in the
Yes,
13th, so
yes, sir.
just briefly.
On the 25 additional assistant district attorneys, last year during the session when y'all had the legislation as a result of the Criminal Justice Reform Act, particularly the weight-based drug prosecutions and the push for accountability courts with the money that y'all allocated for accountability courts, both of these things are going to cause increased workloads in our offices. Our discussions with the Texas prosecutors, which I understand was one of the models that y'all were looking at, when they went to the weight-based prosecutions out there, the number of pills that they had to do increased significantly dealing with the weight-based issue. On the accountability courts, even though there are a number of circuits that are already operating accountability courts, you know, we've gotten the message loud and clear. We need to do something different rather than just keep sending them to prison repeatedly. So we're on board with that. We're certainly willing to look at the accountability courts. But those of y'all who are in the courtroom know that without an accountability court, we look at the file, we decide it's going to be a plea, we make the offer, we go before the judge, we plead the case. We're through with them unless they come back on revocation. Not so with the accountability courts. This is very labor intensive for our people. First of all, of course, we're the gatekeeper. We, as the constitutional representative of the folks, the people who decide who needs to be prosecuted, we're deciding who's appropriate to go into that program. We're having to have these staffings with the other individuals involved in the courts, in the accountability courts. Then we have to go to court. Now, we've started one in Colquitt County, in our circuit.
I understand, and
okay.
We got a kind of shortage of time, so let's compress this. The discussion we had earlier, at least Chuck and I had, was that what we have done, because we understand that it's labor intensive not only for you but also with the judges, but what we did was just throw more money into additional senior judges so that they could move resources around to where they needed them, where there were gaps, where there were backlogs where there were choke points. And my question is, why can we not do some kind of similar model for this rather than hiring 25 full-time people?
Well, we have started doing some research on how we would allocate these 25. I will tell you, Mr. Chairman, that you know, in our discussions with the governor's office last year and this year, we had the governor's office support to give one additional ADA per circuit, and then how we were going to allocate those were going to be prioritized according with the accountability court's a big factor, which Chuck can go into in a second. But let me just point out that the last time the legislature gave us an across-the-board an assistant DA for each DA's office was when Mark Taylor was still lieutenant governor, and that's going back a while. The state funds approximately 30% of the personnel in the DA's office. You fund about 43% of the assistant DAs. But we've gotten to the point where with the additional duties on us, we need help across the board too. But let me defer to Chuck to talk about what we've already done in terms of deciding how to implement and allocate.
Mr. Chairman, pursuant to some conversations you and I had, what we've done is we sat down and I pulled together the Accountability Court Committee of the Prosecuting Attorneys Council, and we set up a tiered level approach to evaluating what's going on in the current circuits, what's going on in the circuits that are beginning courts, and what's going on as far as alternative sentencing and pilot programs that aren't truly accountability courts, and how that we would adequately deploy a limited number of assistant prosecutors into these things. We've created a 3-tier level, one being existing accountability courts, and again the other one being new. We would also take these, the Prosecuting Attorneys Council would maintain the ability to take these personnel, and if we were to make a determination initially that they were being deployed and used in a very proficient manner in a circuit, and that was to change at a later point, then we're going to have the ability to pull that personnel back and deploy them in a place where we think they would be better used. So we're not just turning 25 assistant DAs over to the circuits and saying we'll never see them again. We're actually going to maintain the ability to make sure that they are actually being involved in not just accountability courts, but other alternative sentencing programs and pilot projects like what are going on in some circuits with day reporting centers and other things that the DA's offices are involved in to fast-track cases and to otherwise find alternative sentencing things to keep them out of the prison system. So hearing very loudly where this suggestion is coming from, in another day or two, I'm going to have a written document for you that actually lays out exactly how those tiers apply, how we'd evaluate them, how we're going to use that staff to develop these best practices, and to how we're going to allow the more experienced ones also to come back and go into the new counties where we're implementing the programs and help them set it up and train their people and show them how to do it as well.
So from a budgetary standpoint, how would they be, I mean, assuming that we've got tier 1, tier 2, tier 3, however it is, are they assigned to a district attorney, or are they assigned to the PAC, and then PAC pulls them in and pulls them out, or how's it going to work?
PAC is not in a position where it could daily supervise assistant DAs that are managing cases within the circuit. So they would be initially assigned to a district attorney's office according to need. But what I'm committing to you is PAC will, and the council will maintain the authority over whether or not those personnel that have been deployed to that circuit. Say if we send one to Fred Bright's circuit and they shut their accountability court down, then we would have the ability to pull that allocation out and then take it to David Miller's where they're creating 2 new accountability courts. So we would have the ability to do that. We can manage that within our rights now.
Let me just give you a quick anecdote. I got an accountability court myself. We don't mind, and I'm handling it right now myself, and it's called grab an assistant DA. Rather than have one person in there, which we've lost recently, I'm just having the judge grab whoever she can get. We don't mind being the front-end gatekeeper. The back end, when they flunk out of the court, we'll deal with it. I tried point blank to get out of what I call the middle, which is going to all the staffing, going to accountability court when they get a dirty drug screen, whatever. That's 2 or 3 full days a month. We don't have, and I told my judge flat out, we don't have the time to do it. She said, Fred, it's required we're under a federal SAMHSA grant. You got some DAs that love these courts, some that aren't crazy about it. You got some of us, to be blunt about it, and I'm consider myself in that boat. I'm hanging on for the resource. I'm hoping and begging July 1 we'll get this extra person. If we had another person to assign to it, we'd do it. That person doesn't exist. We desperately need help to handle the accountability courts. And to my knowledge, and I invite anybody to correct me if I'm wrong, we've got this additional burden. We haven't had one additional penny to handle this additional burden, not one from the state, and I don't have any locally, and I don't think hardly any DAs have gotten any local funding to help out for that additional burden of accountability courts. And I'd invite somebody to correct me if I'm wrong in that.
We had talked a little bit about doing some contract services. I mean, if you need somebody 2 or 3 days a month and they are less of a prosecutor than they are the representative of the DA's office and the staffing and stuff like that, why couldn't you, just like, you know, SAG is you know, the Attorney General doesn't have assistant attorney generals all over the state. They go grab one when they need one, contract with them, and pay them for it.
We can, Mr. Chairman, and one of the things that you and I have talked about, and I've talked to about with my district attorneys, is I've got several circuits that have got some unique situations where we can partner and pay a portion of a salary or a portion of a salary in one circuit and the other. And what I'm trying to stress to you is we want to maintain the ability to do that, but I'll have to work that out on an individual basis within circuits, because each circuit is unique as to their approach to these courts. I do believe that we will have the ability to spread resources across boundaries, but it's going to require cooperation. It's just like you and I have discussed about requiring cooperation of the courts. There's nothing out there right now that would require a court to be cooperative of the fact that I have to share a prosecution asset amongst multiple courts. And as you know, judges are not all that interested in hearing about the problems of getting the prosecutor to court.
Which is why, you know, whether you use the SAG model, I mean, they're used for child support cases, they're used in defects cases. I mean, why could that not be a model where you just contract with somebody to be 2 or 3 days, you know, a month or whatever it may require, just like it's done all over the state in all these other courts?
And that may very well work in a lot of places. But what I'm trying to avoid, or what I am trying to make everybody understand, is one of the reasons it works in the AG's concept is everybody works for the AG all the way down. What I have is a unique situation where I run the state agency that supports the prosecutors, but the prosecutors themselves employ their assistant DAs and are responsible for prosecution within their circuit, not PAC. So I can't have PAC lawyers working for me that then go into their circuits and handle their cases on a regular basis. But we can look at individual circuits, and Fred may say that he needs a half of a prosecutor, and David is the next circuit over and he needs a half a prosecutor, and we can work that out amongst those two circuits in an area. That may very well be possible, but we've got to do that on an individual basis after we know what resources we have.
Okay.
Chairman, respectfully, you know, that's only focusing on the accountability court issue and not the rest of the workload. Whereas if we get an additional assistant DA for each of our offices, they can not only work the accountability court, but they can help with this other workload too. And I just hate to see us drift away from this concept of an assistant DA per circuit, which is what the discussion has been for a year, to go into, you know, the analogy of SAGs.
I just have one quick comment. If you've looked at years ago, I don't know if it's been corrected, what SAGs are making, I promise you, or at least in my opinion, it's much cheaper to hire an assistant DA than a SAG. Some of the SAG, they get paid for sitting in court, point blank. They charge by the hour. The SAGs I'm used to handle child support and juvenile court. I didn't ask for it. They came to me, the sheriff. Fred, do you realize how much money we're spending in juvenile court before? Bottom line, I run an 8-county circuit with one juvenile prosecutor from Moultrie, from your neck of the woods. He makes, I don't know, $55,000, $60,000 a year, and he's been with me, gosh, going on 10 years now. And before, there were 2 part-time prosecutors in that court. Part-time, they could still engage in the private practice of law, and I believe they were making over $200,000 a year between the 2 of them. I know one was making $125,000. Commissioners came to me and said, Fred, this is a waste. Will you handle it? We think we can do it cheaper by hiring you an assistant DA. And I said, give me the resource and I'll do it. But without the resource, I just can't do this job by myself. I think, but to answer your question, I think it is a lot cheaper to hire an assistant DA than a SAG. And I've seen some of the figures that the Attorney General, I think he's trying to revise that, what the SAGs are making. I know I've seen the higher figures, I'll word it that way.
Well, I think the litigation as opposed to the day-to-day grunt work are two different things as far as what SAGs make.
I've seen what the one that handles juvenile court deprivation hearings make, and it's a nice. It's more than my assistant DAs make.
Okay. Anything else on that issue? Any questions from the committee on that issue? All right, let's go to the next one.
Okay, on the 8.2.2, the promotional steps for the retention of experienced ADAs, in FY09, we had the step increases that were only implemented for the first 3 months, and then the others were frozen out. Those are the people that are addressed down there in 8.2.4. Y'all gave us the money last year to give those step increases for the people who were left behind in FY09. So through the end of this June, they will be caught back up to the one step that they missed 5 years ago. But for everybody else, there has been no step promotion for those people since FY09. And so far in this fiscal year, we've lost 31 assistant DAs. That's almost 3 times what we lost at the beginning of the recession when the economy and the budget went bad. Historically, and I realize you don't have to do things that way because it's always been done, but historically in this state, people who excelled and did well, they moved from the county positions into the state positions, just like county deputies moved to the state patrol and the GBI. Now we're seeing instances where people are leaving state-funded felony prosecution positions to go to work for the counties to prosecute misdemeanors for substantial pay raises. The state has fallen behind the counties in compensating our attorneys. So we don't want to get in the position where we can't keep career prosecutors. Fred and I are sitting here. We started back in the early 80s when we had the promotional schedule. You could look at that and say, okay, maybe I'm only going to make $21,000 right now, but if I stick with this as a career, eventually it'll pay off. Just like your teachers who look at their salary schedules and their promotional steps to decide to go into teaching as a career. We've got that, but we've been frozen out of that for the last 5 years, and now we're afraid that we're going to get to the point where we've already lost 31 this fiscal year. We're going to get to the point where people are going to be abandoning prosecution as a career. And as a policy matter, we just think this is an important thing to have people who will stay with you and do the job, because an experienced prosecutor can make mature decisions on who needs to go to prison and who is appropriate for accountability court, who is okay for a day report center. They can size up a case that can't be won in the courtroom and go ahead and dismiss that case instead of taking the cases and wasting taxpayers' money on cases that we can't win. We are firm in our belief that we have got to retain career prosecutors for this. We've had people that could not afford to come to work from us, who wants to come to work for us from the public defender's office. They can't afford the pay cut to come work as assistant DA. And I will say,
all right, we're believers.
Okay.
Next.
We just talked on the 100 that did get the step increases for this year, and then that leads us down to the travel. Let me tell you, our travel right now is $450,000 currently budgeted. The DA's budget is 99.5% salaries and benefits, 0.5% travel. Mr. Speaker, Mr. Chairman, you know one of your concerns is how we assess these fees to the citizens of the state, then don't use it for the money that it's supposedly be used for. You know better than me, there's boo-koodles of money raised in the prosecutor, peace officer, and Indigent Defense Training Fund. But we've got the situation where we are now less than half of what our training was, our travel was 7 years ago. And what we need, there's 22 circuits that have said we need more travel money in order to finish out the year. They're running red ink, and the counties, quite frankly, the counties are paying this extra travel for the DAs when the state law says that the state will pay for the DA's travel and the per diem and the mileage just like they do for legislators. And this is, the counties are carrying the bundle on the personnel. They're carrying all of our operating expenses. The only thing y'all budget, that y'all pay for is that formula as to how we're funded for employees, and then a little bit of travel money. This $150,000 is a big deal, especially to the DAs in the rural multi-county circuits.
You've gone to meddling now. No, I mean, we fixed it, not with travel, but we fixed it, at least on our side on the 13. we'll take a look at it and we'll try to help y'all out on that. Is there anything else? I think all the rest of us have got some place to be at 4 o'clock. All right, we're adjourned.
Thank you.